Good afternoon, everyone. Good afternoon. Thank you all for coming on time from the break. My name is Kuba Mačák. I'm a legal advisor at the International Committee of the Red Cross, and I have the honor and the pleasure and the privilege today to moderate this fascinating panel. So maybe just a few words about the themes of the panel and how I think it might all come together, and then we will see towards the end if you agree with me. So a few words from the perspective of the ICRC. Perhaps you're wondering why someone from the ICRC would be standing here. So as a humanitarian organization, we monitor the technological developments and the ways that especially military technology develops and how these are being used. What are the potential human costs of such uses of new military technologies, and then the extent to which the law might need to be clarified or further developed in light of these military developments and the potential human costs. And so also, together with the CCD-COE, of course, the organizer of our wonderful CyCon, we have a joint project called the Cyber Law Toolkit, where I have the pleasure of acting as the general editor on the side of the ICRC, and there are 5 other institutions that participate in that. And that project, as many of you know, some of you being involved quite closely, looks and explores many of the themes of how international law applies to cyber operations, which is what we will be discussing to a great extent today as well. So the name of the panel, new technology and state responsibility, you might be forgiven for thinking, well, we are at a conference on new technology, so aren't all panels a little bit about new technology? And state responsibility, when you have international lawyers, probably all matters of international law could, to some extent, be reduced to questions of state responsibility, which forms a part of the fabric of international law here. So if you want some other suggestion on what to focus on as you're listening to our 3 wonderful speakers today, let me suggest that all of these 3 papers share that they explore this triangular relationship between humans, technology, and knowledge. And knowledge in the sense, knowledge that humans have of the uses of this technology, and sometimes the ways that the uses of technology distort our understanding of what's happening. So what do I mean by that? We will have Petr Stejskal, who is on my right, from Palacky University, and he will explore how knowledge of a situation that's created by the use of new technologies can sometimes be based on a flawed understanding of the facts that we have. And so his topic will be to look at deceptive misattribution. And so he will be presenting a paper that he wrote together with Martin Fikes, who is also in the audience. Hi, Martin. It's very nice to have you here as well. So then we have Arun Sukumar from the Fletcher School of Law and Technology. Sorry, Fletcher School of Law and Diplomacy. But indeed, looking at how the knowledge that new technology can provide us, so these vast amounts of complex information that automated threat detection systems can provide us, what impact this knowledge can have on the obligations that states have. For example, the obligation of due diligence. So again, very much this theme of exploring the interaction between humans, knowledge, and technology. And then we have Tsvetelina van Benthem from Oxford University, who will look at autonomous weapon systems and the extent to which the uses of autonomous weapon systems are covered by human knowledge and human intent. And so what happens if these autonomous functions of such technologies result in unintended consequences? And so what are the legal implications of this under IHL? So I think with these small teasers, you can already see that this is a fascinating panel. I look forward to exploring, these threads that will go through the panel together with you during the Q&A. And because you're all here not to listen to me, but to our panelists, I have the honor of presenting once more, so on my right-hand side, Dr. Petr Stejskal, who is a lecturer in international law at the Palacky University in Olomouc in the Czech Republic. And he's also currently a visiting researcher at the University of Vienna. And his topic is legal aspects of misattribution caused by cyber deception. Petr, the floor is yours.
Okay, thank you, Kuba, for the introduction, and good afternoon. It's a big pleasure to stand here and share our research with such an expert audience and diverse audience. As already announced, we will be today speaking, or I will be speaking about the research of me and my colleague concerning cyber deception. Just To briefly go through the contents of our topic of the presentation, I will explain what exactly we mean by attribution that we address in our presentation, what is the concept, and what legal aspects we actually address, because it has many legal aspects, of course. Then we will focus on these aspects from the point of view of different actors. Just to briefly explain, deception is generally an activity that we can encounter in basic interactions as individuals in everyday life. The deception that we address in our research is a situation, which I will describe later in great detail, but from the beginning it's necessary to understand, is a situation when one state decides to conduct a false flag cyber operation against another state with the aim that this another state misattributes this attack to another victim state, third state, and responds to some measures against the third victim states. And this response to the victim state might, or is, in our scenario, is the aim of this false flag operation. I will provide some examples that this actually might happen and that we already have some cases of false flag attacks. Of course, by their nature, we don't have always data that we need, but this is also a concern for intelligence agencies. Also, NATO CCD COE prepared just this year a report on mitigation of consequences of false flag and no flag operations. But quite interestingly, this issue didn't attract the attention of at least legal doctrine so far. It's discussed obviously in technical sciences, in IT sector, but not in international law as far as we are concerned. Therefore, in our research, we focus or we present this concept of misattribution caused by deception. We point to its complexity and to some extent of legal voidness in that regard. We focus on issues such as the relevance of mistakes of fact in developing responsibility, responsibility of the deception as such, responsibility for the measures, retaliatory measures, and the following. So first of all, as I already explained, what do we mean by cyber deception? Generally, deception by definition is a situation when two parties interact. One party causes the other party to adopt as a true, specific, incorrect version of reality, with the aim to cause that this other party behave in a way that benefits the deceiving party. Just very general definition, but it's probably part of our daily lives. If we see advertisements, we can see it in the sport, we can see it on the interstate level reality that to some extent society or members of society engage in deception. It's also part of interstate relation in terms of negotiation of treaties, application of treaties. Of course, it's also utilized on operational level as a military tactic. From another point of view, it's also part of cyber defense strategy in technological sense. We focus on cyber deception, as I described, as a specific and more advanced form of deception, which is now looming in practice, where there is a specific element of the aim of causing misattribution to a victim state, and as part of this aim, also retaliatory measures of the deceived state against the victim state. What we do not address in our presentations are the questions of the obligations on primary level, of the use of force, breach of sovereignty. We also do not focus in detail on rules of attribution, as they are already discussed extensively elsewhere. We focus on the explanation of this scenario and implications on the level of state responsibility. So in our hypothetical scenario, these are the responsive measures which are the aim of the deceiving state. In terms of methods that can be utilized, we believe that in order to really cause strong retaliatory measures against the victim state, as indeed the goal of the deception, the false flag cyber operation must have certain level of gravity. So these preliminary or primary false flag operation could target critical infrastructure of the deceived state, electric power grid, and it raises the question of the legality of this false flag operation as such, which we will describe later. In terms of technical means, of course I'm a lawyer, so I'm not expert on IT sector, but practice already shown that it's technically possible to leave false traces in a cyber sector by either using specific segments of codes, which are known to be used by specific non-state actors or state actors, which are available in some depositories, archives, or which were otherwise unveiled. This, of course, doesn't go alone. It's usually accompanied by intelligence. It can be also accompanied by falsely provided intelligence information. And it can be also fit or put into the overall political scene and motivations of targets, because attribution as such is not focused only on forensic technical level, but is a multi-layered operation where another aspects, including political and intelligence service information, are also part of that analysis. Just to provide some examples, maybe the most known example is the so-called Olympic destroyer malware, which were used in 2018 in the Olympic Games in South Korea. Originally, this attack was traced back to North Korea, but later, months later, it was unveiled, at least by the US and UK, that the original actor is actually the Russian FSB, not FSB, GRU unit, that used some codes and other footprints that were pointing to North Korea. It also makes sense on the level of policy because, of course, because of the rivalry of the two countries. So this is one of the examples which caused quite severe damage to this event, because the visitors and also the athletes and also representative states, their devices were hacked and not functioning. Other examples are seen usually as aiming to point to Iran, for example. So we had multiple cyber operations in Middle East or against Israel, where false traces are left in order to point to Iran. So, for example, Chinese units allegedly attacked Israelis' governmental and non-governmental targets. Originally, they used traces and tools usually used by Iranian groups, including the language, etc. But later on, it was revealed that it was China rather than Iran. Also, Russia is using the same strategy. There are some documented cases where they attacked multiple targets in Middle East. And this selection variety of targets, it perfectly makes sense that Iran would be the author, because it fitted to its overall strategy and interests. And it also used some segments of codes used by Iranian actors, but it was actually Russian Turla group which utilized this method of deception. Of course, these are just few cases we have which are publicly known with some certain level of probability, and by the nature of cyber deception, we do not know how many of these operations were conducted with success of misattribution and some severe damages. But the problem with that strategy is that it's actually the cyberspace offers a space and methods for utilization of that strategy for gaining a goal of harming third country with potentially little costs for the deceiving state, and usually also hidden behind the mystery of policy considerations, because states do not want themselves to unveil maybe misattribution or these other steps. But if we look at the scenario which I just described with some brief examples, we can see that there are actually two acts of two distinct actors which we need to distinguish in order to qualify them legally. So if we focus on the false flag operation as such, we can ask what are the legal consequences. Of course, it depends on the nature of the operation. Typically, it might be rather some severe form of operation, or at least the malware that is at least capable of causing some serious injury to the state infrastructure, which would have higher probability of really motivating the deceived state to counteract. So we can analyze this operation if we have information, and on the level of primary law, it can be the breach, typically the breach of sovereignty of another state, prohibition of intervention, and also eventually maybe prohibition of the use of force, really depending on the nature of this false flag operation. However, more interesting question is whether this deceiving state can be responsible for actually the response of the deceived states against the victim state. Because if really the whole aim or the whole goal of this tactic unfolds and really the deceived state responds to the allegedly wrongdoer with same or measures or countermeasures and other measures, it is a question whether the deceiving state can be somehow responsible for the damage caused to the victim state. It's actually a very compelling question. We analyzed the rules of international responsibility because it's possible that the basic principle is that we have a principle of independent responsibility. It's also possible that there is a joint responsibility, plurality of responsible states for the same conduct. But moreover, international law also provides for the concept of derived responsibility. So there are specific forms of derived responsibility where one state can be responsible for the conduct of another state. And these are aid or assistance, coercion, or direction on control. We analyze those grounds for derived responsibility, whether this scenario fits to any of them. What is relevant in that case that, of course, the victim state would have a claim against the deceiving state. Deceiving state might have been internationally responsible. And at the same time, depending on which of these grounds would be utilized, the deceived state might, for example, have a plea of force majeure and maybe evade his responsibility. For example, if we had a case of coercion. But if after a closer look into these grounds for derived responsibility, we can see that this scenario does not fit to any of them. In terms of aid or assistance, of course, it's natural that the deceived state does not know the origin or the true origin and intent of the deceiving state, so it's probably not aiding or assisting, at least not willingly. With respect to coercion, there would have to really be some coercive element, and in situation where the deceived state is not aware of any deception, it probably is not deprived of a freedom of action. It just decides on its own to respond to the victim state as an alleged wrongdoer or not. With respect to directional control, there would have to be some relationship of dependence between the deceived and deceiving state, which of course also is not the case in this scenario where deceived state is not aware of any activity of deceiving state. So we can see that the rules of international responsibility, as we understand them, do not allow for developing responsibility of the deceiving state for the conduct of the deceived state. So we also analyzed another grounds. We asked or looked into international law whether the act of deception as such could not be in violation of some primary norm of international law. Deception as such is not regulated in international law, with some small exceptions. In the law of armed conflict, we have the prohibition of perfidy on operational level, but generally rules of war are not prohibited. It's stated by additional protocols 1 and 2. There may be also some bilateral or multilateral agreements of friendship, commerce, and cooperation between the states. Then maybe the deception could be contrary to these agreements, depending on their existence and text. But on general level, on the level of general international law, we had difficulties in finding any positive obligation which would be breached by the mere act of deception, by doing a false flag against another country with the intention to cause damage to the victim state. However, we have some principle which can be close. This is the sic utere tuo principle, which can be expressed sorry, this is the slide, which can be expressed by the no harm principle. But again, on one hand, this principle serves as a limitation of state sovereignty. It would also have some advantage for the victim state because it would not have to necessarily establish intent of the deceiving state. It would just have to establish that it failed to prevent its territory to be used, contrary to its rights. But there are problems with this principle. At the first step, it's still debated whether no harm principle exists as an obligation, separate obligation as such in context of cyberspace. It has been originally developed in case law related to environmental law. However, there are many authors today who have an opinion that no harm principle is already part of customary international law. It's also what the Tallinn manual is indicating. So this is one question to really understand the nature of no harm principle. Another problem which we encountered is then the application of that principle to this conduct. Is a question whether the responsive measures of the deceived state against the victim state, such as countermeasures or another cyber attack, whether this can be understood as a harm caused or originating in the territory of the deceiving state. On one hand, we can say that maybe the effect of misattribution as such may be the harm, which is the harm in the sense of no harm obligation. If that was the true, if just the misattribution would be sufficient to establish harm without really needing actually responsive measures from the deceived state, then we could argue that this harm is originating from the territory of the deceiving state if it used its own organs or infrastructure. But one may also argue that this is not the harm which was actually caused to the rights of the victim state, and this is the responsive measures, the countermeasures, which were utilized by deceived state against the victim state. And in this case, is a question whether these, if that would be the harm that we need for application of that rule, whether that actually could be considered as originating from the territory of the deceiving state, because it was the free decision of, free decision of the deceived state, even though influenced by a false true. So this is still an issue which is under our research, which still probably needs to be addressed and confirmed. But our conclusions are that the application of no harm principle on this scenario is very complicated. Last issue which is opened by this scenario is actually the responsibility of the deceived state for the responsive measures which were motivated by misinterpretation, misattribution. If the deceived state responds to originally unlawful activity, it can be qualified as a countermeasure. But countermeasures have different conditions, and one of the most important conditions is that it is actually aimed against the author of the wrongful conduct. And objectively, victim state was not the author of the false flag operation, and the rules of international responsibility are based on an objective character. So it is the objective truth, the objective reality, which plays a role in establishing responsibility of a state. It also opens the question of the relevance of the mistake of fact, whether it actually has a role in developing responsibility of the deceived state for misattribution. Our conclusions are that mistakes of fact does not play a role in establishing its responsibility because, again, mistakes of fact as such does not constitute circumstance precluding wrongfulness. It also cannot be applied within another existing circumstances precluding wrongfulness. And all of these circumstances are to a certain extent also based on an objective assessment of the situation. And it's been stated by the International Law Commission that when deciding whether to resort to countermeasures and in developing international responsibility, the considerations that we have are objective, and the subjective elements do not play a role. Therefore, our conclusion is that international law does not provide also ground for the deceiving state to escape the responsibility for misattributed countermeasure. To conclude, what do we see in very briefly, that when we look at the conduct of the deceiving state, it's not fitting into any of the established primary norms, as we at least could analyze so far, and it's not also fitting into the construction of international responsibility. So it's very hard to develop responsibility of the deceiving state for actually the intent of the goal of the deception, which is the countermeasures by the deceived state against the victim state. On the other hand, when we look to the conduct of the deceived state, international law also proved to be short, as it's very difficult to evade responsibility for the deceived state for the conduct it did against the victim state because of the objective character of rules of international responsibility. We can discuss what would be the policy considerations, of course. There's another question, maybe for the discussion, but the best solution probably is that the victim state and the deceived state cooperate and communicate, and they can settle the consequences of the countermeasures. But of course, if that would be the aim of the deceiving states to include in his scenario 2 non-friendly states, the Pacific solution would be quite unlikely. So thank you for your attention, and that's all from our side.
Thank you, Petr. I'm going to remain seated here so that we continue in an informal way. So thank you for this very well-structured and carefully constructed argument pointing at possible legal gaps, and I'm sure we will be exploring that further. But now, without any further ado, I want to go to Arun. So Arun Sukumar is a PhD candidate at the Fletcher School at Tufts University in the US and a predoctoral research fellow at the school's Center for International Law and Governance. I managed to say it without any mistakes this time, I hope. And so Arun's topic today is responsibility to detect, autonomous threat detection, and its implications for due diligence in cyberspace.
Thanks. Can I also remain seated?
It's up to you.
Thanks.
It's up to, yeah, as you feel more comfortable.
Thank you. The sound on my watch that you heard when the session began was the wake-up alarm from where I was last. So if this goes south and you feel something is missing, you know what to blame. Thanks, Kubo. My topic, the topic on which I've written the paper, is the implication of autonomous threat detection on the principle of due diligence. So let me start with a couple of caveats. First is that I'm focusing on a very specific pathway that threat detection technology is taking. It need not be the only way that threat detection technology evolves. It ultimately is a factor of research and market-based developments. But I feel that this is likely to be the mainstream way in which future developments in threat detection technology are likely to evolve, because it solves, as I will get into in just a minute, a hard problem of cybersecurity. And in the process, I argue that it may solve also the hard problem of due diligence. And the second caveat being, unlike Petr and Tsvetelina's papers, which point to a gray area in international law that they are focusing on, I'm really not looking at a principle. Of course, there are debates about the application of due diligence, as all of you in this room would know, but really is the effect of this technology inducing compliance with due diligence and, at best, providing an expansive interpretation, making possible an expansive interpretation of due diligence to the sense that it is comparable to the application of due diligence in other principles of other domains of international law compared to cyberspace. So that's really the modest objective of the paper. And with that, the first task is really to challenge, to identify the hard problem of cybersecurity that network operators face, even if they can even be called that today. And so, with apologies to William Gibson, who said cyberspace is a consensual hallucination experienced daily by billions of legitimate operators, that is today the state of cybersecurity. Because it's extremely difficult to monitor modern-day networks. Primarily, I argue for three reasons. The first being that networks operate in heterogeneous environments. So if you are the sysadmin of a network, and if you are responsible for monitoring the security of the network, you have to account at a minimum, for three things: the security of the terminal devices that your employees or the people who are part of that network are using, the security policies of the data processing layer, which is often outsourced to AWS or Microsoft Azure or Alibaba Cloud, or you name it, some cloud operator. And third, the increasing offloading, the increased offloading of networking functions to a Cloudflare or a VMware. This is called network functions virtualization, and many startups or many small companies that do not have the resources to do routing or packet switching or forwarding functions on their own, or just don't have data centers of their own, are simply just handing it over to big companies that are becoming central points of failure. And we have seen it in terms of the attacks on AWS or Microsoft Azure. And that's true for the network layer as well, which is not often discussed in the same terms as the cloud-based services. And this problem of multi-tenancy, and so this is called multi-tenant environments, essentially has been compounded by the phenomenon that we know of work from home. And so the idea of, and I'm hardly the first to say, the idea of a security perimeter as something that is either geographically or spatially confined is absolutely not true at all. In fact, it has become rapidly obsolete, which makes cybersecurity and threat detection much more challenging in today's world. The second problem that I identify is that of the API-ification of everything. APIs, for the uninitiated, although there will be few in this conference, application programming interfaces, they're basically lines of code that allow for software to communicate with each other that are essential in all three layers that I spoke about, whether it's at the application or the device level, at the data processing layer, and also at the network functions virtualization layer. By the way, the last layer, the outsourcing, is not just of routing or forwarding functions, but increasingly of firewall functions or SSL functions as well. So it's a fairly critical layer in that sense. And APIs essentially connect these layers to one another, as well as the main providers to their clients. APIs are the, for lack of a better phrase, the duct tape that holds the internet together. Today, they are, I think Akamai estimates that 83% of internet traffic today is API calls, these pings that happen between APIs. But they are notorious for their insecurities, whether it's lax security, the presence of so-called zombie APIs, APIs that have been created for a particular purpose, but nobody wants to update it. Nobody thinks it's worth their time to update it. So all manner of data breaches that have happened in the last few years, you can probably attribute it to API flaws, including the one on Parler in 2021, on Microsoft 365. The log4j is a vulnerability, but the main point of vulnerability, exploitation of that vulnerability, is APIs. So, and APIs, again, have been known for exposing data in a maximalist way, have been known to be prone to credential stuffing attacks. So it is a problem that has received, unfortunately, very little attention from the international legal community as well, given that they are floating in the ether, they are all over the place, and it's clearly a transboundary problem, but something that's here to stay, given that they do, at the end of the day, provide interoperability to services and critical functions that are essential to the internet today. There are also design flaws that are associated with, or poor understandings of APIs that are associated with APIs. For example, a recent study, a technical study, found that APIs that were provided by Amazon and Google for things like facial recognition, the people who actually used Amazon and Google's ML APIs for facial recognition, they did not know how to distinguish between object classification and image detection. They're two different things. The object classification happens within the image, whereas that is conflated for the image itself. So you can see that this is a grave problem, but like I said, something that hasn't really received a lot of attention. But in short, it makes threat detection a lot more challenging. Also because you don't really know. I mean, there's clearly no legal response, which comes to my third point. No clear national regime, maybe overgeneralizing this, but there's no regime that clearly states, the response. Is it the developer's responsibility, the API developer who develops the API, given that there are north-facing and south-facing APIs? Which API has resulted in the data exposure or the breach or the attack? These are, somewhat technical questions that have no clear legal answers. And finally, related to this, data protection policies have tended, with rare exceptions, to focus on the last mile, that is the relationship between the user and the device. I don't think that has changed. And this makes, again, given the fact that the multi-layered nature of digital networks makes cybersecurity challenging, it's really surprising that data protection policies haven't really, again, with rare exceptions, haven't really focused on stuff that's happening outside of the relationship between the user and the device. Although there have been some policy responses, some strong policy responses. For example, Australia in November 2021 passed a law that would essentially allow it to commandeer the resources of cloud-based providers if they felt that the cyber threat in question is extreme and the cloud-based provider has not provided adequate remedies to its clients, including critical infrastructure that is owned and operated by the government. But it's really anybody's guess whether these kind of post-facto measures, you can imagine this, the outrage if this were an authoritarian government that came up with this kind of a policy response. It's also not a good precedent, I feel. But these are the kind of responses that you see of governments to the problem of securing multi-layered digital networks. Faced with the problems that I have mentioned, users or commercial operators essentially have three options to autonomously detect cybersecurity threats. And I mean, here's the sort of the important part. It's not really the autonomy of the models that I'm reviewing that really make it important. It's the fact that they are able, through autonomy, to cover all aspects of all layers of the digital network that I'm talking about: the device, the data processing layer, and the network layer. Faced with the problems that I outlined below, commercial operators have three options. One is to go by a layered security model where the device security is managed by the provider of the device or the application, the developer of the application. Cloud security is provided by Amazon or Azure, or whoever it is, and the network security is provided by Cloudflare. Given that there is likely to be inconsistencies in the security policies of these three services, this is probably not a good approach to follow. Second is a host-based security. Increasingly, if you are an owner of a business or a startup, you will realize that Amazon and Microsoft are themselves providing security, which they claim to have a greater visibility over the network than just the cloud service. I don't know to what extent this is true. That's one option. And given that most small companies are likely to put all their eggs in one basket, in one cloud service provider, this probably makes sense. And given that you increasingly reach the law of increasing returns kick in with regard to these big cloud service providers, it probably makes sense to go with their security, because then Amazon can inform you of some threat that has not affected you immediately, but is likely to in the future, given that they have experience dealing with threats elsewhere. The last is third-party security. So I guess you could approach a Checkpoint or a CrowdStrike or a FireEye, which claim now to increasingly use autonomous threat detection and multi-cloud detection. So you don't have to be locked into a particular vendor, even if it's cloud-based or network-based. But these three, again, they just provide for autonomy. They don't fully tackle the problem of the multi-layer problem of cybersecurity and that of monitoring digital networks. So I'm going to talk briefly about two projects, two multi-stakeholder projects. One is a pilot project that received, I think, $2 million or something euros from the EU, which has the backing of major telecom operators like Ericsson, but it's also developed by academic researchers. So take this with a pinch of salt that this will be the model that is going to be implemented in the years to come. The ASTED project, which stands for Addressing Threats to Virtualized Services, essentially involves three components, which the image corresponds to roughly as well. A data plane, a control plane, and a management plane. What the data plane does is interface with all elements or all layers of the digital network, including the device, the cloud layer, and the routing layer or the firewall layer. manages, because all of these layers have security policies that essentially involve collecting logs or collecting security details from their kernels or libraries, and the data layer of this application essentially pings them to get that information. The control layer, which is essentially a plane that runs on intelligent algorithms, dictates the data layer to say that you should be devoting this much resources to the collection of data based on some anomalous traffic that we are seeing, and based on the data that is sent by the top layer, it is able to arrive at inferences and learn based on a certain volume of unusual or anomalous activity. It can over time say confidently that this is the nature of the threat, this is the intended target, this is the source of these threats. That's with respect to the control layer, and the management layer essentially is the human-facing element of this application or of this framework. This framework can be abstracted to create any kind of application. Two things are necessary for this kind of application to happen, which are in the works. Hence, it fits in the new technologies remit of this panel. The first is the availability of computing resources to do all of this. You have to, if you're a small business or startup, you need to be able to offload computing resources to gather data from various components of the network, and also to continually learn based on the inferences that are being developed by the algorithm and the data that is being processed by the application. I think this is closer to reality because computing resources today are not hard to come by, at least for the limited purpose of what we're talking about. What is even more important is the presence of interoperable standards. For the data layer to ping, say, an application, a cloud layer, and a network layer, they all should respond, providing data to this program. And for that, you need to develop interoperable standards for network security functions. This project, too, is currently underway. It's called I2NSF, Interface to Network Security Functions. This is one initiative that has been developed, that has been created by a group of actors, which includes major companies under the umbrella of the IETF. And hopefully, this project, as well as comparable projects, can lead to the development of comparable interoperable standards. So this is the technology part. And how does it help operationalize the cyber due diligence principle? Specifically, I'm not to get to this into great detail, but specifically, I want to say that the due diligence principle also requires that the standard of care that's owed by states is, it cannot be the same that they ordinarily employ in domestic concerns. It has to be specifically addressed to tackling significant transboundary harm. Also, there is this recommendation by the ILC when they were discussing the subject in 2001 that states should keep abreast of technological changes. So, and it's these two principles of due diligence as it is applicable to cyberspace that this technological development, I argue, will really tackle. I think it will enhance the scope of obligation of states in cyberspace. Just to sort of step back for a minute, states can take advantage of the application that I mentioned or the framework that I mentioned in two ways. They can either develop an ATD application of their own and say all private actors, all public actors in their digital economy should use it. They can mandate it by law. If not, they can develop an API and ensure that, or they can essentially ensure that such applications that are used by private sector actors or public actors essentially are connected through an API to their certs, which are notified of their threats of such threats in real time. And what ATD applications do with respect to cyber due diligence, I argue four things. One, it helps specifically mitigate transboundary digital harm. One of the problems that states face, both with respect to the threshold of actual and constructive knowledge, is that there is no alignment, I feel, between the legal standards and technical standards today. Actual knowledge, which would be when a state is either aware or notified in good faith, is the GGE language, is actually not enough for a state to meaningfully address, to stop harmful actions, harmful digital operations that are occurring in its territory. Because, for example, the Mirai botnet. if you take the example of the Mirai botnet case, the infiltration or the compromising of digital infrastructure had occurred months before the actual botnet attacks began. And at the time the operations begin, it might be too late for a state to really stop the digital harm, the transboundary harm from taking place without corrupting the integrity of the digital infrastructure in question, depending on the scale of the operation. And I feel that ATD applications can provide a modest solution to this problem by ensuring that the learning component of the ATD application tells you that this is the port from which this threat has originated from, or this is the point of vulnerability that has been previously targeted. We are observing anomalous activity, and therefore this is where this threat is originating from. And also, crucially, say that this is based on previous behavior. This is likely to be the intended target of cyber operations. I mean, it may not be completely, and this is the human interface that's critically important, but providing that kind of knowledge with regard to the originator, the source, and specifically the destination can provide, can be helpful in operationalizing the due diligence principle. Aligning in the legal and technical thresholds, I've spoken briefly. And I feel, more importantly, it can, I think please correct me if I'm wrong, but I think the consensus seemed today that the application of due diligence in cyberspace is limited to stopping digital harm rather than an obligation to prevent and to detect and prevent. And I feel that autonomous threat detection technology provides the avenues by which states can at least detect. Maybe they will still not have the resources to prevent it, but certainly the ability to identify harms at an early stage and therefore expand the scope of the obligation to what it is in, say, environmental law. And finally, autonomous threat detection can, I feel, also, this is the argument that I make in the paper, identify operations that are transiting through territory. Transiting is essentially a feature of routing, rather. This is a feature of routing. It is not random, but it's usually the shortest path that data takes, and it's either the availability of computing resources that makes a difference, or the presence of ASNs and root servers and so on and so forth. Whereas with the ability to learn based on previous behavior, a state, I feel, could have greater confidence, say that this operation is, this anomalous behavior is transiting through my territory for the express purpose of creating digital harm that is of a transboundary nature. And I feel this is one of the reasons why you feel, why you see countries that are regional hubs like the Netherlands and Singapore have two different views on the application of due diligence. Netherlands being for the application of a very strong principle of due diligence to cyberspace, whereas Singapore, which may be a factor of both its resources, but as the tensions in Asia and Southeast Asia may make it more cautious, has a much more measured and cautious approach to cyber due diligence, and says that you have to really come to terms, you have to have more clarity on the degree of knowledge that is required to operationalize this due diligence. And I feel that technical measures like ATD can help transit states, so-called transit states, operationalize this better, and their agreeing to the application of this principle is critical to the universal implementation of cyber due diligence, because they are the states that have key internet exchange points, key critical internet resources that are shared by a number of countries, and therefore their buying into the cyber due diligence would be would be crucial to the overall acceptance of this principle. So that's where I'll stop. I know that's a lot of information to take in, but hope it was helpful. Over to you.
So thank you, Arun, for this presentation. I would say that, in the best of traditions of CyCon, really marries the technical analysis with the legal analysis as well. And thank you also for, explaining some of the technical terms to those that you describe as uninitiated. I mean, I plead guilty as charged, but I'm going to remember from now on that application programming interface is the duct tape that holds the internet together. I mean, that's something that I'm definitely taking away. So thank you so much. And I think that's a very good bridge to our third presentation, which is by Tsvetelina van Benthem. And so Tsvetelina is a researcher at Merton College at the University of Oxford, and also at the Oxford Institute for Ethics, Law and Armed Conflict, and also a lecturer in international law for the Oxford Diplomatic Studies program. Today, Tsvetelina has a paper on exploring changing battlefields, autonomous weapons, unintended engagements, and the law of armed conflict. So the floor is yours.
Thank you, Kubo. I will resist the trend of remaining seated, because without my glasses, I really need to be very close to the screen with my slides. It is a pleasure to be with all of you this afternoon, and it was such a pleasure to hear these two presentations, which link really well with what I'm going to be talking about today, and that was very well summarized by Kubo at the very beginning, when we think about this triangular relationship between users, technology, and knowledge. So what we will be talking about in my presentation is ruptures of intent. We'll be looking at ruptures of intent that occur between the point at which a party to conflict initiates an attack and the attack's outcome. So in a way, what we're looking at is when things do not go according to plan for the attacker. I'm going to narrow down this topic, which is quite big in itself, in two ways. The first one is to be looking at a specific military capability, on this occasion autonomous weapon systems with autonomy in their target selection and engagement. And the second way in which I'm going to narrow down the topic is to look at the framework of the law of armed conflict, such that I exclude legal qualifications under international human rights law, under international criminal law, and other applicable rules and regimes. Now, something which is interesting about many of the topics within the area of technology and law is that while we focus on a very specific question, on this occasion, unintended outcomes and autonomous weapons, these debates raise questions around the applicability and the scope of international legal rules, such that they expose certain gaps in our understanding of even fundamental rules of regimes such as the law of armed conflict. So this is what I'll be focusing on today, how factual uncertainty and legal uncertainty really drive us to a point in which we're not entirely sure what is prescribed and what conduct the party to conflict needs to engage in to be in compliance with the law. So the specific inquiry on autonomous weapons is going to go through 3 stages, and I know that we all have an enchantment with 3 easy steps to things. So we're going to be looking at first the problem, second the law, and third a way forward. When it comes to the problem itself, we'll be looking at features of armed conflict more generally, and certain new ways in which war is being waged and how they affect uncertainty. On the law, while the paper addresses 2 prohibitions under the law of armed conflict, the prohibition of attacking civilians and the prohibition of indiscriminate attacks, for reasons of time, I'm only going to be addressing the first of the 2. And then when it comes to a way forward, what I'm interested in is really investigating the role of positive obligations under international human rights law, and their role as information generators, and how these information generators interact with the operationalization of the prohibitions. Now, the problem. There are many layers of factual uncertainty in the way in which conflict is waged, and these factual uncertainties can be generators of significant harm to civilians. Consider, for example, information uncertainty. This can lead to the misidentification of targets, and we have many unfortunate examples in which a party to conflict intends to engage a lawful military objective, but factually directs its attack against civilians or civilian objects. Another concern are weapons malfunctions, because here as well we see a disconnect between the intent of the attacking force and the actual outcome. So with both these scenarios, when it comes to mistakes in identification and with malfunctions, there is a mismatch between the intent and the way in which the attack actually unfolds. Now, these uncertainties are not new. Even writing in the beginning of the 19th century, Clausewitz talks about the great uncertainty of all data. Malfunctions happen as well. Rifles misfire, missiles go astray, laser beams get deflected. There is an acceptance that when we talk about weapons, there is a level of tolerance of error, so we cannot expect that there is going to be perfect operation at all times. But there are certain ways in which the landscape of conflict is changing. One of them is, for example, when we think about the localities of conflict. Many contemporary conflicts are waged in urban centers. Now, this exacerbates the risks to civilians. Why? First of all, in itself, the fact that it's waged in urban centers, but also because of many tactics of groups that may be hiding behind or within the civilian population. And then a second form of uncertainty, which is a new one, is the ways in which autonomy is getting introduced within the decision-making processes, such as there is an additional decision-making element on specific selection and engagement of targets that occurs after the decision-making to employ a system, a weapon system, towards the point of impact. So with this in mind, we can think a little bit about autonomous weapons systems. There have been many discussions around the risks of unpredictability that reside in them. When I talk about autonomous systems, I'm going to be talking about a degree of independence in the selection and engagement of targets, but it is accepted that autonomy is not a yes or no question. It's something that comes in degrees, it comes in relation to different functions of a system, and also it can accommodate different types of supervision and interaction between humans and the machines. Now, the reason why this is an interesting topic to start thinking about unintended outcomes is because they raise very starkly this question of how intent is traveling from the humans in the party to conflict to the battlefield, to the ground. And there have been many discussions already for decades, really, between a range of stakeholders, most prominently maybe at the group of governmental experts on lethal autonomous weapon systems, which is convened within the framework of the Convention on Certain Conventional Weapons. And what is really helpful is that this group, there was an acceptance that international law applies to these weapon systems. Now, this is important. Why? Because applicability of international law is the gateway for us to even consider how international law applies, which is the second and the more complex question in the analysis. In this presentation in the paper, I do not argue for a ban on autonomous weapons. I do not argue for a moratorium on autonomous weapons. I do not argue for new rules on autonomous weapons. It's just a very narrow question under existing law, which is, what are the legal consequences when a party to conflict initiates an attack and there is an unintended outcome? Now, this takes us directly into the second part of the presentation, the law. We talked about factual uncertainties, now we transition towards legal uncertainties. And legal uncertainties, even though we have had the law of armed conflict for a very long time, still reside within the elements of many rules. And there is still a significant interpretative disagreement over not just definitions and standards, but also even the very existence of certain elements within those rules. Now, this is not great. Why is it not great? Because, of course, having clarity on the law allows parties to shape their conduct. If we're unsure about what is required of parties to conflict, this has implications for what we can claim is a breach and for accountability. And of course, this also minimizes the deterrence function of the law. And very often, we hear this narrative in the literature about accidents, about things going wrong, some abstract things. For example, after the August 2021 Kabul attack by US forces, we heard that there was a tragic mistake, but that there was no violation of the laws of war. Very often there is going to be some ex gratia compensation that is going to be given without acknowledgement of responsibility. So the question is, can we test that narrative? Can we test the narrative that unintended outcomes are not covered? And in this sense, I'm very happy that Petr already addressed the fact that mistake of fact is not a circumstance precluding wrongfulness under international law, at least within the framework of state responsibility. So in this sense, there are no easy answers, such as to say, if there is no intent, there is no violation. If there is a mistake of fact, there is no violation. We have to do the groundwork, and the groundwork is go to the primary rules of the law of armed conflict and investigate, which is what we're going to be doing now. we'll look at the prohibition of making civilians the object of attack, which exists under both customary law and treaty law. So what you have in front of you is Additional Protocol 1, Article 51, Paragraph 2, which tells us the civilian population as such, as well as individual civilians, shall not be the object of attack. In the paper, I engage in a lengthy process of treaty interpretation, but I'm afraid that I'm going to put all of you to sleep if I start doing this now. So what I'll do is to just draw some elements of this analysis that really led me to the conclusion with which I'll start, because you don't need to go through the entire journey. It is prohibited for a party to conflict to launch attacks in circumstances of doubt regarding the status of a target. And I see Mike smiling in the first row. We'll get to this. Okay, so on the spectrum of interpretations as to this prohibition that you saw here, we have some who argue for a purely objective approach, whereby they would say, if you, as a party, as a matter of fact, direct an attack against civilians or civilian objects, this is it. That's all that you need. So this is a purely consequence-based approach. Then on the other hand, you have those who would be arguing for intent. They would say it is only the intentional direction of attack against civilians that would count, such that this would cover purpose or knowledge. Where does this fit? Somewhere in the middle. So this is not a purely consequence-based approach, and it is not only about intent. So of course, instances of intentional targeting will be covered, but as you can see here, there is an additional question which is about situations of doubt. Now, why am I saying this? If we go through the rule of treaty interpretation, the ordinary meaning of terms does not tell us that much in itself. It does not preclude any interpretation, but if we turn to the context of this provision, we can first have a look at rules that contain specific subjective elements. And one of them we can find in the second sentence of Article 51, where we see that acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. And in many places of Additional Protocol 1, you can see that where the drafters intended to have subjective elements, they would list them explicitly. The second piece of the puzzle, which is probably the most important one, is the provision on grave breaches. Why is it important? Because a grave breach here is defined as what we saw in Article 51, Paragraph 2, combined with a standard of willfulness and certain consequences. Willfulness has been interpreted not only in the ICRC commentary, but also in the jurisprudence of international tribunals as covering not only intent, but also recklessness. So just reasoning from this, if a grave breach is the prohibition that we saw before plus willfulness, then the provision itself should mean something less. And then finally, in interpreting this provision, tribunals for individual criminal responsibility, most notably the International Criminal Tribunal for the former Yugoslavia, have interpreted in that rule the presumption of civilian status. Why am I referring to these? You would say this is about individual responsibility, because in their analysis they were interpreting that rule of international humanitarian law before proceeding to the other elements for the war crime. So based on these three factors, plus of course this is confirmed by the object and purpose, from which we can derive a protection from the dangers of military operations for civilians, I say that this leads us to this conclusion on scope. How is this operationalized in practice? When we think about human decision-making, by reference to the construction of targets of attack, we're thinking about information generation in ways in which you get information about the status of a target, you verify the reliability of your sources. If need be, you get more information. You test biases within the process. So you try to make sure that you're forming an accurate picture of reality as to what you're about to attack. So this is typically something that happens within a human factor of the party to conflict. And one good example of how this should work in practice is when we consider the March 2022 attack against the Marple theater. If you remember, civilians had inscribed Deti on both sides of that building. Why? Deti means children. So they were trying to alert their children who are hiding in that building. Now, for a human, this is going to entail certain consequences. You would think that there is at least a risk that what you're thinking of attacking shelters a person who ought to be protected. On that occasion, it seemed there was either carelessness or malice when it was constructed, but the idea of having these signifiers is that there is going to be an additional information generation process such that you can make sure that the status of your target is, in fact, lawful. With autonomous weapon systems, much of this process can be transferred to the machines. Why? Because certain functions of selection engagement of targets are not going to be in the hands of human decision makers as they traditionally may have been, but they're going to go to a weapon system, even though there is a degree of control at the level of programming as to how they're going to operate. They have sensors, they gather data, they have processing systems, they have algorithms, and all of these have to be tested. Individuals have to be trained on them, such that there is going to be an assurance that they're going to be acting the way in which the party itself has to be acting by reference to protective needs. So this is really the bottom line of what I'm getting at by combining this legal prohibition with autonomous weapon systems. When a commander or operator is deploying an autonomous system that can independently select and engage targets, the way in which that system selects the objective is part and parcel of the method in which the party to conflict is constructing the objects of attack, such that if you have not programmed the presumption of doubt, if you have not made sure there is good verification mechanisms, it cannot be said that you're really complying with your obligation as a party to conflict that ought to protect civilians. And then finally, a way forward. As you can see, there is a lot that goes into this that is related to information, to available information, to how information is being generated. And there are obligations under international humanitarian law that bind parties to conflict to take certain measures. Some of these are precautionary obligations, such as target verification. We have obligations to do legal reviews of new weapons. So all of these obligations are obligations that generate knowledge about the systems that we're employing, about targets, about the deployment environment. And this is why, through fortifying these obligations, we can get a bigger pool of information by which we're going to be assessing the decision-making of the parties to conflict. There is already an understanding by states who participate in the group of governmental experts on autonomous weapon systems that these procedural obligations are really important. And we can see this across the board. It is not just the non-aligned movement, for example, that has been arguing for a ban moratorium, but it is even the US, the UK, who are saying that procedures are going to be key in ensuring safety of these systems. Available information is really shaping our expectations. And this is why the hope is that by having these information generators with us in our arsenal, they're going to feed into the decision-making of parties, and are going to minimize the risks of unintended harm of those that we ought to protect in war. So really what this is just a call for more and better information in the way in which parties make their decisions in conflict. Thank you.
Thank you, Tsvetelina, and thank you also for highlighting the role of information in generating information and what legal implications this has, and also for sticking to the time, which I really appreciate. We have about 20 minutes left in the session, and you know how the moderators always start by saying, I'm going to abuse the privilege of being a moderator. I'm not going to do that unless we don't have any questions in the audience, which I find hard to believe because we had 3 really thought-provoking presentations. So with that, you know, I would encourage you to raise your hand if you already have a question. Is there anyone in the audience? Okay, I see Asaf in the front row. Do we have more, just so that we already know? There will be another one, in the gentleman in the back. Okay.
So thank you so much. My question is for Tsvetelina, which I thought was a terrific and mind-boggling presentation, and I'm really looking forward to reading the full chapter. I have an interest in getting more of your insight into some of the phraseology you used, in particular the word doubt, and how you conceptualize that word. Even before we need to complicate the matter further with autonomous systems, we can start with intelligence use in the context of these operations. And I've been thinking a lot about faulty intelligence in the context of aerial strikes. And so, to what extent does the use of what is suboptimal intelligence in deciding a particular military operation, one that should be deemed as a doubt that should therefore result in the operation being dismissed? And are those just ultimately probabilistic analyses that are percentage-wise determined, and that militaries could always move away from saying, well, we didn't know, but that was the intelligence we had at the time, and we need to make decisions on the basis of something, and that's the only available information we can have.
So maybe before you answer, let's take also the second question. I think we already have the microphone in the back. Yes, and is there anyone else? Okay, and then Mike. So we take these three, and then I let you all answer, and then we see how much more time we have. Please.
Hi, so my question was also for Tsvetelina. My question was, do you think that in a hypothetical situation where an autonomous weapon is employed by a commander and it unintentionally targets, or it does target, a non-combatant, do you believe, just based on your research, that the Rendulic principle is still applicable in that sort of situation? Or is the application of the autonomous weaponry, does that begin to erode the distinction there for the commander? Thank you.
Thank you. And we also have a question from Mike. Professor Schmidt.
Comes as no surprise that my question is for you as well. When you were doing your research, were you able to identify any country at all in their military manual that took your position that a mistake of fact meant that there was a violation of IHL? And were you able to identify any country that actually goes to war that took the position that any doubt whatsoever precluded executing the attack?
Okay, so we have three questions for Tsvetelina, so it's not unfair to our co-panelists. We'll give Tsvetelina a little bit of time to think about the order in which you take them. You'll be the first one to answer, okay? But I'm going to pose two questions to our co-panelists just so that we have a bit more discussion going. So Petr, when I was listening to your paper, I was thinking, okay, you have identified this legal gap, right? So deceptive misattribution, it leads really to a gap in our understanding in the law. So that's a problem. Mm-hmm. So what would be a solution? I want to push you on this a little bit. Lex ferenda, now you have free range. What rules would you propose that would address this? How do we modify the current legal framework in an effective way to deal with this problem? Just if you have any ideas on that. And Arun, on yours, I think, by showing us these new methods of effectively monitoring modern networks. I hope I can say that and that it reflects the crux of the argument. You have shown how the scope of the obligation of due diligence can be enhanced in certain situations. But could we say that the availability of these new methods also triggers a new standalone obligation? In other words, the fact that states might have these autonomous threat detection systems at their disposal means they must use them because it's feasible, from the IHL perspective, for example, so it becomes a passive precaution, something they must do to minimize civilian harm. Or when we are in the peacetime situations, perhaps, again, it would be a standalone due diligence obligation on those states that can afford it, because I know you make that point in the paper, that it's a question of affordability. But those states that can afford it actually must do so. So that would be my question for you. But let's start with Tsvetelina.
Thank you so much for three excellent questions. I think I can probably combine Asaf's question with Mike's question and then turn to the one on the Rendulic rule. On the question of doubt, the question is, how do we construct doubt? And a starting point for this is to say that, at least in the jurisprudence of international tribunals, it has been looked through an objective lens. So it is not about the subjective beliefs of attackers, but we're looking at what a reasonable person, this imaginary figure that we really like talking about in law, would have done in the prevailing circumstances at the time, which goes back to the question of what information you had. Now, the second question from this is, this does not tell us much about what doubt means exactly. There are some views that doubt means certainty. There is no one who argues that it means absolute certainty. So there is the additional question of what degrees of certainty are we thinking about? Whether we can think about something that ties this to a notion of reasonableness, for example, and what this reasonableness would even mean. What is clear is that you need some affirmative evidence on the status. Why? Because of the very way in which we define civilians and civilian objects in a residual way from what we have about the lawful military objective. So we have to have some affirmative evidence that there is a lawful military objective. And then the question is how this evidence that we have relates to how certain we are about the nature of a target. And I know that Mike has written about this, John Merriam has written about this, so there are many people who have looked at this question of how do we think about doubt? Is this about reasonableness? Is there a formulae behind this? Is this a question of certainty? I would say that there is no problem with the formulation of certainty as such, if we accept that it's not about absolute certainty, but that there are gradations of certainty. And ultimately, it's about a question of careful and diligent decision-making, how you construct your targets to attack. So to your question, Mike, which is related to this one, and which was about state practice, the way in which states interpret the prohibitions themselves, and whether they interpret this rule of doubt or a mistake of fact within them. Now, a first just methodological question is to say that when we think about what states say, this may play various functions. What they say and they do, it may play a function in customary international law, in the development of a specific rule, and it can play a role in treaty interpretation, but if we think about subsequent practice, it will be subsequent practice that would be establishing agreement on the interpretation of a rule. So if our treaty analysis shows that the rule of doubt is to be interpreted in, and that we do not require intent, then we would have to show that there is agreement in state practice that changes that for us to be able to say that we even need to consider individual pronouncements as determinative. Now, do states say that doubt is to be interpreted in the rule? What they typically do is to just restate the formulation of Additional Protocol 1. There are states that say that it is only about intent, the UK and the US being prime examples here. But again, these are two states within a wide pool of states that are just repeating the formulation of the protocol. And ultimately, it's about the question of seeing what this protocol means within the terms of the protocol, within its context, and object and purpose. And just a very brief point, because I think it's quite interesting that in debates within US Congress, when they were thinking about Additional Protocol 1, they were actually objecting to the fact that the rule of doubt implies a standard of certainty. So it's interesting that by even rejecting that idea of this rule, they implicitly affirmed that there is a degree of certainty within the way in which the protocol is constructed. And then the third question, which is also excellent. So even if in the Renderlich rule we were thinking about honest mistakes, it was still constructed in the way in which the tribunal looked at it through a substitution of the tribunal in the shoes of the person and in the circumstances at the time, which actually aligns with what I'm saying, which is that it's not about honest mistakes. This is not a way to get out of this, but it's about thinking of what you had available at the time and what a reasonable attacker in your circumstances would have done. Now, as we discussed by reference to Asaf's question, this is exactly what needs unpacking. And this may need unpacking in a compartmentalized way, depending on the types of capabilities you're using. So this may mean something different now that we have autonomous weapons that it meant without them. I hope this answers all three.
Thank you, Tsvetelina. You want to start, Arun?
Can I
You have a finger on that. Okay,
so
go ahead.
Does that mean, Tsvetelina, that algorithms will be subject to review? I mean, so Asaf talked about intelligence as a basis of collection, right? Would states be willing to open up, say, proprietary algorithms that underpin these weapon systems and say, you have to show us that there is this degree of reasonableness of doubt that reasonable doubt that you're crossing? Is that something that would?
Yes, absolutely. So if you as a party to conflict need to show that you have respected the rule of doubt, then you have to show that what you're deploying to operationalize that principle is compliant with it. In that sense, this is going to raise, of course, questions of confidential information, what you may not want to share, but you'll have to show some evidence that in the programming of this algorithm you did comply with the rule.
But you're not going to get out of your question by asking another one. So now it's your turn, and then we'll go to Petr.
Okay. So I think, honestly, I don't think states would commit themselves to an obligation that they must. Even if the technology that I'm talking about, it's not quantum or anything. All it requires, basically a few lines of code and the computing resources. And I think most states in the world have access to those computing resources, or if not, the ability to offload those computing resources to some major companies. And the question really is, with respect to IHL, I'm not an expert, so I think you would know this better than me. So I don't want to get in there and sound stupid. But I would just say, we should weigh the consequences of a state of states, of taking states in that direction. These ATD applications are not going to be implemented by states for the sole purposes of their cyber due diligence obligation. It's going to be for bread and butter, national security, cyber security. Do we really want governments to engage in deep packet inspection? Because a lot of governments would engage in deep packet inspection, maybe some for the right reasons, some for the wrong reasons. Increasingly, even DNS communications are encrypted. I don't know if you've heard DNS over HTTPS, something called Quick that Chrome uses today. Most DNS communications, not just the content, but even the header of the packets is encrypted. You would have to break that encryption, or you have to inspect those packets to detect where threats come from. And I think that's fair game, but do you really want all states to engage in deep packet inspection, especially those that have a track record of violating human rights? So, I think it would be tough to say that an obligation, a specific obligation would emerge out of this. But it would be great if the standalone, the due diligence obligation can be sort of actualized to its fullest sense with the help of the app. And that's really the objective of the paper.
Thank you, Arun. Petr?
Thank you for this question. Actually, I believe that maybe there are 3 avenues where the law could develop, given the fact that our hypotheses are correct, that there is indeed a gap. I think that on one level, there could be a primary norm developed that generally prohibits such an activity which has the sole intent of causing a dispute between another 2 countries. So not only deception and misattribution, but generally this kind of, let's say, provocation or aggression. That could be on one hand. The question is how to do that. Another level where the law could develop maybe is the level of rules of responsibility, where we could maybe develop 4th ground of derived responsibility, just perfectly fitting this situation. So when the state is actually frauded into commission of intentionally wrongful act against a victim state, that could be also attributable to the actor of that operation. But also there is a question and a problem that still the response of the deceived state is based on its own deliberate decision, even though it's originating from fabricated facts by another subject. So it's still a question. A 3rd possibility may be the development of a procedural obligation going far beyond the general duty to cooperate between states. In cases of that, to communicate at first before resorting to countermeasures or another measures to the alleged wrongdoer, to some procedure of communication. But it doesn't prevent, I think, conflict as such. We already have these, as we discussed with my colleague, we already have procedural obligations in other areas of international law, invalidity of treaties and termination of treaties, and it still doesn't prevent that we end up with a conflict. And of course, if I would be the state who would like to induce misattribution by deceiving, I would choose as a deceived state a state that has not friendly relations with the victim state. So there is not probability also that they would normally communicate. They would just resort back. So I don't know if that answers your question. That could be possibilities, but with limited maybe.
It answers my question, but it highlights one thing that I've been thinking about while you were presenting and also now, and that is that you didn't use the word cyber in your answer almost at all. Maybe there was one mention of it. So it makes me think, to what extent is this analysis technology neutral? That it doesn't really even matter on the fact that this misattribution happens in cyberspace. Would the same analysis apply to any kind of deception by one state of another that would have nothing to do with new technology? Of course, that takes us outside of the scope of this panel, but I think it's quite important for the legal analysis that you're presenting.
I think so. I think that this scenario, as well as the legal background around that, could be also applicable to non-cyber context, physical context. I think it's more or less likely because cybersphere offers much more tools to concealment and deception. And in the physical terms, physical theater of operations, we see the results more visibly and more immediately. So this research really is related to cyber domain, but it's also applicable to other. I think that this scenario can be conducted also outside the cyber context with the same legal problems.
And so maybe this is the right point to plug in the fact that this scenario actually arises out of a cyber scenario, right?
Yes.
That you and Martin wrote for the Cyber Law Toolkit. So those of you who are more interested in this topic, that's where the practical kind of set of facts originates. So there is certainly more on that there. I was scanning the room as there is three more questions. Okay, well, and we have 3 minutes left, so I will have to ask you to be quick with the questions you ask.
Very quick. It's about due diligence. I was confused at your discussion of due diligence, and the reason I was confused is because due diligence is usually about a third party operating from your territory. And in your scenario, the deceiving state, it's actually the organ of the state that is acting. So I didn't understand why you were raising the issue of due diligence or no harm principle, as you call it, at all.
Okay, we'll let Petr think about it. Davide, and can we also get the mic in the back, or you already have it? No. Can we send a mic there? Davide.
Thank you.
Okay.
We all know that some states use non-state actors for conducting cyber operation on other states.
And excuse me, sir, who is your question for?
I am Mohammed. I'm a PhD candidate for University of Oxford.
And who are you asking the question to? Which of our panelists?
I think I would ask the question for all you.
You have to choose one if you don't mind, because we're really running out of time. So choose your preferred one.
For Mr. Van.
Okay.
Yeah. Some states like Russia use non-state actors for conducting cyber operation on other states. Do you think that new technology can make any difference to solve this problem? I mean, states use non-state actors to avoid taking the responsibility of these attacks.
Thank you. So we have a question on non-state actors, and then David, the final one.
Yes, very quickly, a question for Tsvetelina. It's concerning the technological development and in assessing the depth, because as a matter of fact, many states could have better technology rather than other, and so how this will impact in the assessment of the available means and instruments in order to carry out a fair assessment. Thank you.
Okay, excellent. So I will let you each answer in as briefly as you can, Petr.
Okay. Thank you for the question, Professor. We also believe that the application of the principle is very difficult in this scenario. The reason why we raised that issue is that I think that if there is a rule that could be breached, this one is the most closest, maybe. But the original reason is that the very false flag operation of the deceiving state is originating from its territory, and its sole purpose in our scenario is the harmful consequences for the victim state. So if we consider this original false flag operation, which should motivate the second state to actually resort as the harm, then we could discuss whether, it originates from the territory of the deceiving state because its origins conducted that false flag operation, but its intent was not only to do some harm to the deceived state, but to motivate him, to provoke him to respond to the victim state. So, but we still see that there is a big difficulty with application of that principle.
Arun?
I think the only question was on non-state actors. I think with respect to due diligence, there's no need to attribute it to the state. The only question is whether the state has actual or constructive knowledge. That's the only operational factor of the due diligence principle. So in that sense, what the ATD application that I spoke about does is it gives the state a more comprehensive visibility over various aspects of its network. Doesn't matter which non-state actor it is, because it breaks it down into layers, abstracts it into, okay, this is a cloud, this is a provider of cloud services in my territory, and these are the kind of threats that are originating from it. Or this is, if Cloudflare runs operation on my territory and there is a BGP hijacking that's going on, okay, this is happening, and Cloudflare is in a position to know and tell me. And so, these applications can be developed by the private sector as well as governments. And of course, the applications that are developed by the private sector give instantaneous knowledge to those actors, but also to the state. So in that sense, that's the modest link that I'm making.
Thank you, Arun. And Tsvetelina, very briefly.
Thank you. That's an excellent question. Intuitively, the answer should be yes, right? The law should accommodate these differences. When we think about precautionary obligations, it does through the loop of feasibility of precautionary measures. But then the question is, the rule of doubt does not seem to accommodate such flexibility like precautions. So there are probably two ways to address this. One of them is when we think about construction of doubt, that perhaps one factor can also be some kind of available means for you to determine the status of a target. Or the second one would be when we think about the reasonable person in the shoes of that decision maker at the time. Maybe the reasonable person standard is going to be altered on the basis of what exactly you have as capacities to identify targets. So these are the two conceptual ways in which I think that the concern that you raised could be looped in the legal standard.
Thank you so much. So, you see, we have exhausted the time, but we haven't exhausted the topics, and we certainly haven't exhausted the speakers. So feel free to come to them during the coffee break. I think this one is very short because the next panel starts in like 10 minutes. So we have to end here. Could we have a huge round of applause for our wonderful speakers?